You're live. Good morning. It's April 8th in Senate Judiciary. We're taking up page 578, and we have alleged counsel here with us to provide the walkthrough.
Good morning, everybody. Eric Fitzpatrick here with the Office of Legislative Counsel. As the chair indicated, here to do a walkthrough this morning of H 578 as passed by the House. This is an act relating to penalties and procedures for animal cruelty offenses. And you may have noticed already, it's a pretty lengthy bill. There's a lot to it in terms of language, but I think I can describe sort of there's three primary things going on. So I'll describe that for a minute before we look at before we get into the deed for the statutory language. So you've got three sort of big picture things going on in H 578. So right now, sort of the existing process, I think the committee may recall, it's been a little while, I think, since there's been an animal cruelty bill going through the legislature. But the big picture is that animal cruelty criminal offenses are divided into misdemeanor animal cruelty and aggravated animal cruelty. Misdemeanor animal cruelty is, as you might guess by the title, 1 year misdemeanor, generally speaking, maximum 1 year incarceration, 2 years incarceration, maximum for second and subsequent offenses. That's your misdemeanor offenses. Your felony offenses generally have a 5-year maximum period of incarceration or 10-year maximum for second and subsequent offenses. So that's the existing criminal sanction piece that is on the books for current law. In addition to the incarcerative penalties that are provided for the current law, there is a additional ability of the court to impose sanctions other than incarceration and criminal penalties. That includes things like if someone gets convicted of animal cruelty, the court can order that the animal be forfeited. So the person that was the animal that was the subject of the cruelty can be forfeited, as well as any other animals that the defendant might have at the time of the cruelty. The court could also order limitations on the person's ability to possess animals in the future. So not just the animal that was subject to the cruelty, but future possessions of the animal. The court can order that the person have to submit to periodic unannounced inspections to see how their treatment of animals are going.
How would the prohibition on owning animals be enforced?
I'm going to leave that to the practitioner to talk about that. How that works in practice is an interesting question, but I'm not as familiar with how it works out there in the field. But it is something that the court has the authority to do. So now thinking for a moment, what changes does 578 propose for this current structure of animal cruelty offenses? First one is, as I mentioned, you have misdemeanor cruelty, you have felony animal cruelty, and the way those are laid out in statute is there's a long list of prohibited conduct and lists that constitute misdemeanor animal cruelty and some other types of conduct that constitute felony animal cruelty. What 578 does is it expands those lists primarily in the nature of the offense of sexual conduct with an animal. So that is currently prohibited, but the definition is expanded to include a couple of different things primarily. One is visual representations of sexual conduct with animals. So you can almost think of it as obscenity, which is what it's defined as, involving sexual conduct with an animal. And as well, when a minor is involved. So it makes it a felony if a minor is involved. So those are two things related to the felony and misdemeanor offenses that's proposed in 578. So the second thing is that with respect to the additional sanctions that I mentioned that the court can impose, in addition to incarceration and criminal fines, the bill also proposes some expansion there. So right now, as I mentioned, that the court can order that the person not possess an animal either presently, and the animal can be forfeited. It sort of expands that not only to possess, that the person can't work with an animal, for example, can't reside with an animal. So those abilities of the court to impose those sorts of other sanctions are expanded. And additionally, under the current law, those additional sanctions are all discretionary by the court. The court doesn't have to impose them. The court may impose those sorts of things. Another proposed addition in 578 is that for second and subsequent offenses, some of those sanctions become mandatory. Court shall order forfeit to the animal that it's a second or subsequent offense. The court shall impose restrictions on the ability of future ownership of animals that are the second or subsequent offense. So that's another big. Yeah.
Would these be probation conditions or conditions
No.
of release?
No, they're part of the criminal sanction. So
Okay, so as a
court can order
form
as part of
of
the
this,
sanction.
okay, as a part of the sentence.
Yeah, exactly. Yeah. And then lastly, so there's three big picture things. Those are the first two. Expanding definition of sexual conduct for purposes of the criminal prohibitions, and also some expansion on those other types of sanctions the court can impose when a person's convicted of animal cruelty. The third thing is actually a civil forfeiture proceeding. I know the committee has dealt with that subject and with respect to other topics before, when instrumentalities of crime can be forfeited under certain circumstances. For example, an automobile and DUI cases are subject to forfeiture. Property used in drug offenses, anything that's an instrumentality of a crime, there are guns can be forfeited sometimes. Exactly. So existing law already permits the forfeiture of animals that are subject to animal cruelty. That is in the existing statute. So there is a process for that. But my understanding is, and you'll hear more about this from witnesses, is that that existing process is run into some problems, both in terms of its timeliness, how quickly it moves along, and in the expenses that it creates. Because if you think about it for a moment, and just back up for a second. Remember, this is a civil proceeding we're talking about now. This is not part of the criminal proceeding. There's a civil forfeiture proceeding that can be instituted by the state to forfeit the animal when there's been probable cause to, well, the court finds by preponderance of the evidence that the animal has been subject to animal cruelty. Again, it's a lower standard than a criminal. It's not beyond a reasonable doubt. It's that might be clear and convincing. I think that, but I think the ultimate is preponderance. I think it's preponderance. That's what I thought. Right. I think getting mixed up with our previous discussion and the previous bill. But so that process exists. The proposal here is going to be to provide some ways to expedite it, move it along more quickly, and try and offset some of those expenses. Because when an animal gets forfeited, there's going to be a period of time before the court ultimately makes a final decision on that. And somebody's incurring costs of care during that period of time. Some custodial care organization, could be a humane society, another party who provides care during that period of time, and expenses can become very significant. And my understanding, again, you'll hear more about this from witnesses, is that the slowness of the process can cause both health issues for the animal and extreme expenses that are incurred by these custodial care organizations. So the idea is two things: speed it up a little bit and try and offset those expenses by requiring security to be posted by the person whose animal is seized pending the forfeiture proceeding, so that security can then be used to offset some of those costs. So that's number three, the three big picture things going on. That whole civil process, expedite, establish a requirement of paying security. Sounds good. All right. So with that in mind, let's take a look at some of the language to see how that operates in the details. The first one, and it goes in the same order that I described these three big picture things. The very first one, starting on page 1, is that expansion of the definition of sexual conduct with an animal that constitutes animal cruelty. Again, this is what you're looking at right now, is just the definition of sexual conduct. And that's for purposes of when you got to the actual crime, it'll say, what are the things that constitute animal cruelty? Sexual conduct with an animal. And to find out what it is, you look at the definition right here. And the definition is proposed to be expanded. You'll see bottom of page 1. Basically, the existing law is lines 12 to 14. And that really focuses on, as at line 13, insertion into the animal of body parts. C and D expand that line 16 to include touching or fondling sex organs, or line 19, intentional transfer of semen. So very specific, but specific expansions.
Just wondering on D. So the word semen is not modified by an adjective. Is that human, or because a breeder might be engaged in using animal semen to breed. So it seems like there's a little slippage there in terms of what is being criminalized.
I think the idea there, and whether that word needs to be modified, I'm not sure, but as far as the exempting anything that has a potential valid purpose, that's in line 18, without a bona fide veterinary or animal husbandry purpose. So that exists in line 15, and that's also an existing law, line 12. So any of these things all have an exemption for what might be, as you were pointing out, a situation where there might be for breeding purposes or any other bona fide purpose for inserting semen or.
But what I'm wondering is, it seems like it's in the section where it's saying what things would be prohibited. Insertion, touching, fondling, etc. Here it's intentional transport, transmission of semen.
Without purpose.
Without purpose.
Right.
So it seems as though if it were human semen, there could be no purpose. And if it was animal semen, there could be. So I'm wondering, and it doesn't seem like animal semen would be prohibited. So I'm wondering if we should specify there. Do you see what I'm saying?
I do, but I'm not going to be able to answer that question.
Oh,
so
okay.
I would suggest that you ask some of your witnesses who have more experience with veterinary practices to be able to respond whether or not that needs clarification.
Okay, I would be very surprised if there is a bona fide veterinary practice that requires human semen. But anyway.
Yeah, this is an opportune moment for me to point out that animal cruelty has not generally been it's part of my portfolio. I picked it up this year at the last minute because our legislative council office had an unexpected late departure from our judiciary team. So you'll see that again this afternoon, Senator Rajowski, when I'm in the institutions committee on a different animal welfare bill. So many of the questions that I might be able to answer in other contexts, I will probably have to defer to witnesses on. Just okay, that's up. So
and perhaps this is going to be another space, but I'm wondering if there's any type of definition of what a bona fide veterinary or animal husbandry purpose is. How is that determined? Is it prescribed by a vet? What does that mean?
Again, I think that's a good question for your witnesses.
Okay.
Yep. All right, so moving along over onto page 2, this is adding a definition of working with. This is the reason that this definition was added is because, as I mentioned, in addition to the criminal sanctions of incarceration and criminal fines, the court has the ability to impose other sanctions on someone who's convicted of animal cruelty. Currently, those involve ownership and possessing an animal, but the bill H578 adds the ability of the court to add a prohibition on working with an animal. So, for purposes of that prohibition, a definition of working with has been added. So again,
and this may be a question for the witnesses as well, but it's a little concerning to me that working with doesn't include farming.
Does not include
farming or working with livestock. I don't see that on the list. Is that an intentional? Would this capture that, I guess?
Yeah, I think so. I think it includes working or volunteering in any capacity. So.
Okay, so there's a list, but the list is not necessarily
exclusive. Correct. So yeah, line 2, that word just says including, and the general statutory construction that we have elsewhere. And that including means the non-exclusive list.
Okay. Yeah.
So you can read that whenever you see including, you can read it as including but not limited to. So that's why that definition is there. So now moving on to the actual criminal offenses, that starts on page 2, section 2. This is the misdemeanor offense, misdemeanor cruelty to animals, starts on line 8 and 9. And as I mentioned, the current statute includes a list of the types of conduct that constitute animal cruelty. So that's all existing law. Just see it on page 1, 2, 3, 4. All intentionally killing, depriving an animal of food, water, et cetera, These are all existing provisions. Over on page 3, again, you see no changes here, but those are the existing types of conduct that can be prosecuted for animal cruelty, misdemeanor animal cruelty. Now, so we're moving on to page 4, line 4. And as I mentioned, remember, sexual conduct with an animal is existing animal cruelty. That's line 4, page 4. So engages in sexual conduct with an animal. That's currently a criminal offense. And there's A through F are the types of conduct that are included within that definition of sexual conduct with an animal. And so the proposal in 578 is to add subdivision G, lines 15 to 16. So I mentioned this in my sort of introduction, that one of the ways, one of the two ways that the sexual conduct with an animal element is being expanded for purposes of animal cruelty prosecutions is to do with visual images. So subdivision G knowingly possesses, films, or distributes obscene visual images of sexual conduct with animals. So this expands what constitutes sexual conduct to include possessing, film, or distributing obscene visual images. The word obscene there is intentional to make clear that it's only obscene images that can be prosecuted because obscenity is not protected by the First Amendment. So that's the way you will frequently see federal and state child pornography statutes and other types of criminal use of the word imagery uses the word obscene because the court then interpreted that to mean that means that only images that are not protected by the First Amendment are prosecutable. So that's why that word is intentional.
Wouldn't all of these types of images be obscene?
I think that for purposes of being sure that it can be not a First Amendment violation, the word is there.
Okay.
Yeah. All right. So another couple of additions to the misdemeanor animal cruelty, you see 12 and 13. Those are basically, in a nutshell, as I was mentioning, the court can order these other prohibitions on the person's conduct. If they've been convicted, they can't possess the animal or other animals in the future. They can't work with, etc. So there isn't anything in the current statute, though, that provided for what if the person violates that? What if the person possesses an animal even while they're under, while an order is in effect that they not possess an animal? So what these two provisions do is make that a misdemeanor offense as well. The person possesses, owns, cares for, resides with, has custody, etc. While they're prohibited from doing so by a court order, that's a misdemeanor. Same thing with subdivision 13 on page 5. If the court orders allows them or requires them to permit the periodic unannounced visits by a humane officer and they refuse, that's a violation as well. All right, so now moving on to the felonies. This is section 3, page 5. Felony animal cruelty. It's called aggravated, but it's the felony. And this essentially takes every type of animal, sexual conduct with an animal that we just looked at in terms of the misdemeanor and repeats it. It says if it's with a minor, either participating or in the presence of the offense being committed, then it's a felony. So it's the exact same offense. But if it involves a minor, it's a felony. That's the gist of it.
So the penalty for a child engaging in this behavior is higher than the penalty for an adult doing it?
No, it's about an adult doing it. It's an adult committing the offense in the presence of a minor or in the participation of a minor. So, other than that language is all identical, other than you see in each subdivision, you see the words, for example, lines 13 and 14, in the presence of a minor or in which the minor is a participant, in the presence of a minor. So it's just repeated each time so that the person commits it.
So a minor could be liable for the misdemeanor, but not the felony.
I think that the participation of the minor may or may not be relative to the defendant. The person who's charged could be an adult, could be a minor. And if it happens to be a minor, it's a juvenile. Then all your juvenile stuff kicks in. So yes, a minor could still be charged, but the fact that some types of this offense are aggravated if it's done in the presence of a minor doesn't have an impact on how the minor is going to be charged. How the minor is going to be charged is under the juvenile. Exactly.
Someone wants to. Yeah, Eric, I do have a question.
Yeah.
I thought it was kind of unusual on page 2, line 10. So a person commits a crime of cruelty to animals if the person intentionally kills or attempts to kill an animal belonging to another. That's a misdemeanor. That's taking the life of the animal. And we get on to page 5. Basically the same thing along to 7, kills an animal by intentionally causing an animal undue pain or suffering. So you can kill an animal, but as long as you don't cause it undue pain and suffering, it's not. It has to be a conflict.
Are we talking about torturing animals? Is that?
Torture is in both misdemeanor and felony as well. That was my question. And I understand it under existing law, but it's kind of a weird.
If you take a life when it's not a felony, it's still good.
Well, again, back to the farming thing again. If you're raising chickens and they're cutting their heads off, that's an agricultural practice. So it's the cruelty or the torture rather than causing death.
Well, that's certainly part of the felony Senator Bohowski was mentioning on page 5, lines 9 and 10. Intentionally, maliciously, without just cause torture, mutilate. So there's some torture that's included within that provision. But I don't know in practice what would distinguish a killing that is, for purposes of the felony, intentionally causing the animal undue pain or suffering,
Right.
versus the I'm not sure what facts as a matter of practice.
Yeah.
And maybe people who work in this area would be able to provide more real life examples of what the difference is. I think, as you mentioned, Senator Ruth, it seems like agricultural practices would be a reason why.
Well, and I'm looking on page 2, that's an animal belonging to another without getting permission or consent. So if I'm reading this right, it seems like the underlying statute is written to still allow the owner of an animal to kill the animal. So in other words, you own cattle and you kill them and you
Right.
So they don't have to distinguish other than to say you can't torture them while you're killing them. But it's remained silent on the legal owner killing them. Am I right?
I read it that way. As you say, for various agricultural food processes, you might kill an animal that you own, chicken, sheep.
And I mean, you don't have to go back too far. People kill their own animals at the end of their lives. They didn't take them to the vet and have them put down. They shot them in the backyard or whatever.
Right.
So it seems like this is a attempt to harmonize the farming and non-farming stuff by staying silent.
But I feel like the silence could lead to an instance where someone killed their animal in a way that was not okay or aligned with farming.
Yeah.
And then that would not be a crime.
Well, if it's undue, then it would be.
Right, because that's an animal, line 7, page 5, not an animal of another person. If you mentioned the first one, it's another person's animal. This one is any animal.
Well, it's not undue killing, it's causing it undue pain or suffering.
Right.
So I mean,
I think
not to use I am gonna use there's been news stories about Christy Nome shooting her puppy. Like that might not have caused it, like it might have been an instant death.
right.
So it wasn't torture, but it was still not farming or, you know what I mean? And under this, because of the silence, I think that's legal.
I think if it would involve us in a whole other discussion if we say that people can't kill animals that they own, then you'd have to you'd have to incentives farming, but you'd also have to I mean, animal is a pretty broad definition. Like fish are animals, right? So if you do something, I don't know, it gets very complicated. That's why I think it's looking at intentionally causing pain and suffering.
But getting away from the farmer scenario. Going back to the misdemeanor, intentionally kill or attempt to kill an animal belonging to another person without first obtaining legal authority. If I go to my neighbors and For instance, as an example, take the life of the dog water, else it's a misdemeanor.
Well, yeah, oh yeah, you're right. If the neighbor didn't consent on this language, yes, that's a
So my question was, I was wondering why it's just a misdemeanor, I guess.
That's the policy question. It's legitimate to think about.
There's a few on the list of misdemeanors that I'm wondering why they're misdemeanors. I mean, when I look at the next line, tortures, torments. I frankly, even the sexual conduct with an animal, it seems strange to me that would be a misdemeanor, but I know that that's existing law.
Well, we can have a committee discussion about all the potential changes and hypotheticals, but we can stick to getting the walkthrough of the language that we have in front of us and understand that, and then we can also have a committee discussion. Put it down for.
Not good, makes sense. So that then would bring us to the penalty section, which is page 6, section 4. This is again existing law, but there'll be some changes proposed that you'll see when we get to the next page. But for the moment, just so you can understand the framework of the way it's set up, penalties starts in subsection A on line 15, page 6. That subdivision 1, that paragraph, that's the misdemeanor right there. So you'll see line 18, that's a 1 year, generally speaking, 1 year maximum fine of $2,000. Line 19, second and subsequent convictions, 2 years, $5,000. So that's your misdemeanor right there. Then turn over on page 7, that's subdivision 2, top of page 7. There's the felony paragraph right there, subdivision 2, aggravated. That's 5 years. See that? Line 2, 5 year max. Line 3, second and subsequent. In that case, see line 4, 10 year max. So there are some wrinkles to that in the rest of the page, but that's the big picture way to understand that misdemeanor. And then all aggravated distinctions. So then I'm going to turn us, all this is existing law that's unchanged there, all the way over to page 8. And if you look at page 8, line 12, you will see this brings us into the second topic that I mentioned, these additional sanctions. You see line 12, that's existing law. In addition to any other sentence the court may impose, the court may require a defendant convicted of a violation under section 352, that's the misdemeanor, or 352A, that's the felony, of this title 2. So these are these additional sentences that the court may impose besides incarceration or the criminal fine. So that's subdivision A. The first one, that has to do with forfeiting the animal that was subject to the cruelty or any other animal that the defendant owned or was living with the defendant at the time. So that is current, but there's some proposed changes here. But currently, the court does have the ability to order forfeiture of any rights to the animal that was subject to the cruelty or any other animal that was owned or possessed. So first change, you'll see on line 15, it says for a first violation. Right? That's because, remember what I said in the beginning, one of the two big changes that's being proposed to these additional sanctions is right now they are discretionary. If you look at line 13, page 8, the court may require a defendant. It's a may. So for that, and the bill keeps that may, that it's not mandatory for first time violations. But we'll see when we a little bit further along. If it's a second or subsequent, some of these things that may becomes a shall. So it requires the court to forfeit the animal, for example, under certain situations. So that's the first big change. But it keeps the may here for first violations. But it does add, you see line 17, it's not just that the animal is owned or possessed that the animal could be forfeited. It says owned, possessed, residing, or domiciled. So the idea is that maybe the person doesn't actually own the animal, but they're living in the same house with the animal. If that's the case, it should be forfeited as well. So that's why that's added. Now, this is kind of a topic that you were touching on a little bit earlier, in particular with respect to agricultural practices, Senator Ruth. You'll see line 16, this forfeiture. There's an exemption in existing law for except livestock or I wasn't here at the time, so I don't know this for absolute, but from what I understand, that was an attempt to say that, okay, the forfeiture of animals doesn't include livestock or poultry, so that a person who's engaged in farming practice wouldn't necessarily have to forfeit their animals, particularly if the maybe they were convicted of abusing a dog, for example. Should the court be able to order that all their cows, sheep, and chickens get forfeited? I think that's what the intent was originally having that language. So generally, that's preserved, but it's also a little unclear the way it's written there. What does that accept that actually mean? What does it apply to? So to try and clarify that, it's set out instead as a new sentence, bottom of the page. So it says, livestock or poultry shall not be subject to forfeiture under this subdivision A, unless the person was convicted of abusing livestock or poultry. So in other words, if that was the animal that they were convicted of abusing, well, then the court could order forfeiture. But on the other hand, if the example I just described, for example, the person was convicted of abusing a dog, then the exemption still exists. They can't then be ordered to forfeit cows, chickens, whatever else they might want for agricultural purposes. So that's the idea of the way that works. All right, so moving on, page 9, and we're still, these are all these lists of other things that the court may order when the person's convicted. Subdivision B isn't really changed. That's just, they can order the defendant to pay all the reasonable costs that they incur when they're providing care prior to the judgment. Not removes the piece that the court state on the record why they do it, why they don't. Down to subdivision C. Now we're talking about forfeiture of the person's future rights to own an animal, right? So there's two different things. The animal is subject to the abuse, which we just saw. Now we're moving into future rights to own an animal. Again, that does exist under current law. You see that line 6, court allowed, it is permitted to order forfeiture of any future right to own, possess, or care for. Again, it's added that language we just talked about, though, also reside with, have custody of, or work with. So that's where that gets tied in, because we looked at the definition of work with, that's how it terms defined.
What is the difference between owning and having custody of an animal?
Like, for example, one might have an animal living in your home that you have custody of. Might be that it belongs to some other person in your family or a friend of yours, or who you are watching the animal for some reason.
You're leasing a horse, so, if you don't have a barn, but you want to own a horse, use a horse, you can lease it somewhere else, or you can lease the barn space and own the horse, but have the horse at this separate barn, and so the
They
other
have
barn
custody of the
would have
horse.
custody
Okay.
in their barn.
Right.
One example.
No, that's a good example. Just a friend of mine has a stable. She used it that one.
The dog is also accessible.
Right.
Right, about.
Yeah. Okay, so yeah, those are examples where custody might be the case. And one other change here, you'll see that the line 7 and 8, this right in the future that the court may order the person to have limitations on, to have custody of animals or phone, etc. Right now, the existing language, line 7, there's no necessarily a limit on how long the court can have that order be in effect for the future, just as for a period that the court deems appropriate. So, the House decided to put an outside limit on that for a period of up to 5 years, but this is just for the misdemeanor, remember, or sorry, first time violation. And it's only, we're still discretion. The court doesn't have to order these things. The court may order these things. Now, for a felony, that's the next subdivision, Roman numeral 2 or Romanet 2, we should say, lines 9 to 11. That's for a first violation of 352A, that's the felony. So if it's a felony violation, in that case, it's the same as what we just looked at, except the maximum period. You see at line 11, it's 10 years, not 5. So if it's a first time felony violation, then you have a maximum of 10 years that the court can say you can't have an animal for 10 years after. Doesn't have to. Again, it's all discretionary. The court doesn't have to do it. It doesn't have to do 10. And then you'll see some Romanet 3, lines 12 to 50. This is again that exemption for livestock and poultry, unless the person is convicted of abusing livestock. Same concept we just looked at. So generally exempts them unless that was the animal that you abused. All right, moving on. Next type of thing that the court can order. This is education involving animal cruelty, prevention programs, education programs, psychiatric, psychological counseling. All those things are also available in the current law. put some tweaking around it, on page 9, with respect to the animal cruelty prevention programs, line 17 to 18, clarified that it has to be one that's approved by the Director of Animal Welfare. Secondly, education program, line 20, also if any are approved by the Director of Animal Welfare. Over on page 10, for some reason, the existing requirement, option for the court to order psychiatric or psychological counseling under existing law only applied, you'll see it struck through line 6, page 10 to juveniles. It didn't apply to adults. And the House felt that seemed to make sense for it to apply to anybody who was convicted of this. So that language is no longer limited to juveniles and instead provides a psychiatric or psychological evaluation could be ordered. And if the screening indicates that therapy is needed, the court could order the person to obtain it. We're now page 10. We're on another thing that the court can order. I mentioned the periodic unannounced visits by a humane officer. You'll see line 13. It's expanded to not only can be the humane officer or the Director of Animal Welfare. So they might be the party who can inspect the animal periodically in the future. The time limit has changed a little bit. Under the existing law, you see line 12, it's only for a period of up to 1 year. It's extended a little bit. Lines 15 and 16, instead, it's for up to 1 year after the expiration of the period that they're prohibited from owning or possessing the animal. So the court orders in effect, and it's for 1 year afterward that they might have to agree to permit these sorts of unannounced inspections. Sorry. All right, so over on page 11, we don't need to go through all these again because it's all going to be exactly the same. It's the only crucial word here, page 11, line 2. This is shall. See that very first word. In addition to any other sentence, the court shall require. So these are some of the same offenses you just looked at. Sorry, the same penalties that you just looked at. But instead, these are a requirement that the court imposes. When is it required? Look at line 4, second or subsequent violation. So if it's a second, so the first offense we just looked at, it's all permissive. Court can order, but it doesn't have to. In this situation, and it's not for all of those, it's just for the forfeiting any current rights to the animal, that's lines 4 and 5, or future rights, that's line 10 and 11. So those two offenses penalties we just looked at. You can order that the animal be forfeited, that the animal is subject to the abuse or is also living in your home. Or you can order the person, the court can order the person not to have ownership of animals in the future, except in this case, if it's a second or subsequent conviction, then the court has to order that. That's the difference between this group and the one that you just looked at. Same time periods though, you'll see line 11, it's that for the future, not less than 5 years for the misdemeanor, and line 14, not less than 10 years for the felony. All right, so we're going to move now to a new process that the bill adds that's starting on page 12. And this may be familiar with folks. It's actually based on, you may recall that I think I mentioned this during the 606 discussion, that right now in firearms law, there's a provision where if someone is prohibited from possessing a firearm for mental health reasons, there's a process where they can file a petition with the court to have their firearms rights restored if they can show that they're either no longer suffering from the mental illness or that there's no reason for them to be barred from possessing it. So this is based on that language. And it's the same idea. If someone is prohibited from possessing an animal, either presently or in the future, or working with an animal that expands on this that I just described, this creates a court process where the person can file a petition with the court to ask that their rights to own an animal be restored. So that's essentially it. It's based in many ways upon that firearms process. That's the statute I used as sort of a model to craft this. So person may petition the court for an order that the person be relieved from their prohibition on possessing animals. The language is really just the process and, you know, how the petition gets filed, where it gets filed, what the state attorney has to show. Court can grant it without a hearing if nobody objects. And it lists the factors the court considers. That's over on page 13. You know, whether the person has committed any subsequent offenses, whether they've completed any required conditions of probation, et cetera. Then, also on page 13, subdivision 4, line 10, court has to grant a petition, in other words, and permit the if the person petitioner has demonstrated by a preponderance of the evidence, the interests of justice are no longer served by prohibiting them from owning, possessing, caring for the animal. If that's the case, that the court vacates this previous order that had been in effect. 13 over on page 14, if the court denies it, it can be appealed. Yep.
Yeah, I got a quick question there.
Yeah.
Is this after using the misdemeanor after the 5-year period, or is this anytime during the 5-year period?
After. It would have to be after. Exactly. It's after they want to have their rights restored. Yeah. Yes, and then there's the last thing on that, page 14, is there's a 2-year time period. If they get denied, let's say a petition is filed and it's denied, the person can't just file one the next day. There has to be a 2-year waiting period. See that line through page 14. You have to wait 2 years before you file another one.
Unless the court says you can file.
I'm sorry, exactly, right. Court can shorten that period. If it chooses. All right, so that's the end of big point number 2. That's all those additional sanctions other than the incarceration as a criminal fine. But now we're moving on to topic number 3. You'll see line 6, page 14, the title of the section, searches and seizures forfeiture. So this is that civil forfeiture procedure that exists in current law that I mentioned. And what you'll see in the details here, as I mentioned, that the perception is that the existing process is this major problem of being too lengthy and not clear enough, and then ends up causing health effects on the animals that are subject to it, as well as costs to shelter organizations. So the proposal is going to be to expedite and accelerate this process. So
Yeah, sorry to interrupt. On 10 or 11, it gets to that acceptable agricultural practices. So the secretary has to weigh in on whether it's, doesn't have to, but is asked to weigh in on whether what is at issue is an accepted practice.
right, prior to forfeiture.
Right.
Or seizure, I should say.
Yeah.
Yep, exactly. And an interesting new sentence relative to that point is you see the underlying section, failure to conduct a consultation, because in general, the Secretary of Agriculture, Food and Markets is required to be consulted before one of these seizure/forfeiture proceedings. And the sentence provides that if failure to do so is not grounds for actually dismissing the action. That is actually memorializes, Vermont Supreme Court held that specifically. But the idea was to make it clear, so put the same thing in statute. So the court has said failure to conduct it doesn't necessarily mean that it has to be dismissed.
That's interesting though, because it's a shall, right? And
Yes.
and they haven't done that, but it never did.
Well, it's
It's a shall in the first line.
they shall be consulted, but there's no statement that the secretary shall engage in the consultation. So they have to be asked, but they don't have to answer.
Right, but then it says, if they didn't conduct a consultation at all.
Oh. Yeah, I feel like maybe that language should be more around the lines of if the secretary doesn't respond. Because it is contradictory if we say you shall do the consultation, but if you don't, that's no big deal.
Yeah, it's a policy decision for you. Absolutely. You can make some changes to that. There's a lengthy, or not lengthy, well, it's there's a statutory interpretation rule that exists in the courts for when does shall, in other words, it's not the shall,
The shall.
Yes, but when does it actually require, for example, what should the sanction for not doing what shall be? And it's whether it should be the action is dismissed, which as you would think is probably one of the more severe sanctions for not doing a required shall. The court goes through an analysis of whether it is, was that contemplated by the legislature, if that was that intended or not. So I think that whatever route you choose, just be clear so that it's expressed in the statute what you think the consequence ought to be for not conducting that consultation.
Well, I guess I mean, we can talk about that because for me, when I think about like the failure should be like if the secretary doesn't respond. So I've reached out to them. They have not done the investigation, that I should be able to continue, as opposed to you're supposed to do this, I didn't. And that's fine. So that I think, I don't know. We can come back to it.
So,
Yeah, I just need some explanation there. Hate to keep going back, but on page 11, I'm looking at line 11. It said, for second or subsequent violations, have custody of or work with an animal for a period of not less than 5 years. It specifies that, and then you're telling me that. So after the 5-year period, I would assume that that individual has those rights brought back in. But you're saying after 5 years, they can petition the courts, and it doesn't exceed. That's my question.
Well, actually, no, so that is that's their future rights, not their present rights. So the court's saying, all right, you can't possess it. I misunderstood your first question. I'm sorry. It's my fault. That's why that was confusing. That's their right in the future to own an animal. So in general, yes, if that period expires, it doesn't have to be 5, it could be 3, 4, it could be 5 is the max.
I thought it said not less than.
Oh,
So it actually has to be at least 5 years. It could be more than 5 years.
Right, exactly. So, but yeah, whatever the period may be, if you're in that period, then the person can't possess an animal during that period. If that period, whatever, 5, 6, 7, whatever it is, runs out, then the person could possess. That's true. But the
When do you file a petition is my question.
yes, exactly. And that may be a wrinkle that we hadn't really thought about as clearly, or at least it's not one that's immediately coming to mind for me. Because I'm thinking now of the present, because that's the future right. Present rights said to forfeit any rights to the animal. That's subdivision A above the paragraph above the one that you were looking at.
Let's say the court set 10 years. Maybe you could petition after 5.
I was just gonna say that.
Yeah.
Exactly. Right.
I guess it's just unclear. But
That's true. Now, I think that the Senator said, so if you read the language on page 12, lines 6 through 8. So, a person who is prohibited from owning, possessing, caring for, or residing with custody and or working with animal by an order issued pursuant to B1C or B2. So that's what we were just looking at. May petition the court for order of approval. So I guess, yeah, where I was mistaken when I said that they have to wait until the end of that period. Actually, it's the opposite. It's during
that period.
Exactly. Because after, you're right, because at the end of that period, well, then they don't need to petition the court for an order anymore because they wouldn't be prohibited.
That clears it up for me.
Yes, sorry.
So it would be any time within the window in which they're prohibited,
Exactly.
which, as I'm reading the language, could be a lifetime prohibition.
That's right, because as you mentioned, it's not less than. So, that brings us, we were on the, we just talked about on page 14, what you might want the consequences to be when the person doesn't consult with the secretary before engaging in one of these, before a humane officer engages in a forfeiture action. Over on page 15, so what is being discussed in existing law there on subdivisions 2 and 3, page 15, and I mentioned this earlier on, is that the way a forfeiture proceeding is typically instituted is when a humane officer, and that can be a law enforcement officer or an animal control officer, if they have probable cause to believe that an animal is being subject to animal cruelty, they can apply for a warrant to have the animal seized. In addition, if it's a situation where the officer actually witnesses circumstances where the animal's life is in danger, then they don't have to apply for a warrant beforehand. They can seize the animal immediately. And that's existing law. So that's the way it is currently. And there's a process that that the bill proposes to amend the process for forfeiture after that happens. So seizure is just the initial custody, but then forfeiture is the legal process by which ownership of the animal could be transferred to the state. And that is what the proposal is to accelerate some of those procedures and also propose this requirement that the person pay a security. So that's kind of where we're at here. And so if you turn the page, for example, over to page 16, you'll see a lot of struck language. Page 16, page 17, that's all the existing forfeiture procedure language. So that's all being struck. And the new process starts at the bottom of page 17. That's kind of where the procedures that will be governing now the situation where an animal is seized by a humane officer and then the state can institute this forfeiture procedure. And I say it can institute, it's not required. The state can then bring a forfeiture procedure wherein the state's attorney has to show, again, as we mentioned, by clear preponderance of the evidence that the animal was subject to cruelty. If that's the case, then it's under forfeiture. That's the big picture of how this works. One of the time changes that's proposed here is under the existing statute. After the animal is seized initially by the enforcement officer, there's no requirement in law about how quickly the forfeiture proceeding has to be instituted. So there can be delays between the time of seizure and the time the court proceeding gets started. So this changes. So under the new process, and this starts at the bottom of page 17, goes over onto 18, the owner has 14 days from the date of that seizure to request either a hearing or a waiver of the security. Remember, I just mentioned that it's also imposing a security requirement. The person has to pay security if their animal is seized. They can also ask for a waiver on the basis of financial hardship, and that's a constitutional requirement. You can't seize property from somebody and forfeit it, and then if they can't afford to pay to contest it, say, well, we're taking it anyway. If they can't afford it, then they have to be provided an opportunity to contest it anyway. You do that by offering a waiver. So that's yeah.
Eric, if they move to have this, well, it's a hearing.
Yeah.
And so if they move to have that hearing, would that have to also happen in 14 days, or is that?
Yes.
Yes. Okay.
Yeah, they have to do that within the first 14 days.
They'd have to petition, but then also the hearing would happen within 14 days
No.
of their. Okay.
No, if they file, they got 14 days to ask for it.
Right.
And then if they do that, right, if they meet their 14-day time period to ask for it, then if you look at page 19, lines 12 to 14, then the hearing has to be held within 30 days after that request. So you got to ask within 14, and then the hearing has to be held within 30 days after that. But again, specific and attempting to expedite these timelines while also providing constitutionally required notice. Because the other thing that's going on here is that someone's property is being seized, right? And in that situation, due process requires that the person be provided with notice and an opportunity to be heard. So how does that happen functionally? That's, if you look over on page 18, subdivision 2, line 5. The humane officer who seizes the animal has to give notice at the time of the seizure by delivering a copy of it to the person who was present as the legal interest in the owner. So if the person is there, they get the notice right then. So they're provided notice, and that notice, we'll see in a second, includes, what you have to do to request a hearing and how you can request a financial waiver, all that sort of thing is going to be in the notice.
Hold on. So this is essentially a TAC order.
Well, yes, that's what I was going to get to. That's if the person isn't there. That's the second sentence.
Does it have, right? So that's.
Constitutionally,
I'll come back.
constitutionally arguable, is that what we're going to get it? The answer to that is yes.
Okay, I had the same question.
Now, I say arguable because I don't think it's clear, but I think everyone's aware that that's a place where you would expect a defendant, certainly, if it came up for a defendant to raise the argument of whether that was, because as I just mentioned, the process requires notice and opportunity to be heard. So the question is a TAC order, which is in my that, yeah, I never knew that so I thought it was spelled TACH. What does that mean? Because TAC, TACH means you tack the notice In this case, you'll see, line nine, sorry, conspicuously posting it in a prominent and accessible place at the location where the animal is seen. So I'm just gonna say that, but go ahead, John.
No, go ahead.
Well, just that, that's questionable as to whether or not that's gonna be sufficient notice. Now, so the cases, I don't think uniformly say that a TAC order is never an appropriate form of notice. It seems to be that they're case dependent. Is it under the circumstances, weighing the interest of the state and the interest of the person, is that going to be sufficient? And to say there's a clear answer there, I think there is one, so I can't tell you that there is. But I think the position that the House Judiciary Committee reached was, given because this only is happening in a situation, because the animal isn't, the humane officer in this case is not seizing the animal unless, without filing an application for a warrant of the first place. Because remember, generally, that's the way it goes. They can only seize it without applying for a warrant if it's that emergency situation where the animal's life is in danger. So the idea was, if the animal's life is in danger and they're posting it at a place where probably the owner's going to see it, right? Because they're taking it from there, then the House, I think, felt, knowing that this could be challenged, it was worth it.
So, all right, so this is only, this TAC order idea only applies to these exigent circumstances. Okay,
Exactly.
okay.
And again, that was the idea that since the court in those situations balances the needs of the state and the rights of the person, and maybe, and just because it's only limited to exigent circumstances, it's at a place where they're likely to see it, does that mean it's going to be upheld? No, but it felt at least arguably that could justify it.
So actually, I guess one more question then.
Yeah.
So in the rules of serving process don't quite apply to this. So like so the officer wouldn't have to get permission from the court to do
Correct.
alternative service or anything like that.
That's right.
Oh,
That's right.
Right.
Because you're right. Generally, you have to try everything else first, right? And get permission from the court, personal service and first class mail, all that kind of stuff before you can do the tag. But this in this particular situation, doesn't require preliminary steps. All right, so that's the method of seizing the animal and the notice that has to be provided. Starting on page 18 and over on page 19, that's what does the notice have to contain? What does it have to include? And you see a lengthy list of material that has to be in the notice. Description of the animal seized, the purpose of the seizure, time, place, and circumstances, etc. Contact information for the person who has custody of the animal. That's line 14 and 15. So the person who has to know where the animal is. Also, the person has to be informed, to subdivision B, page 18, they have to be informed that they have to post security and request a hearing within 14 days. And if they don't, then seizure, the animal will be seized. So it tells them you have 14 days, you have to file your request for a hearing now if you want to. But it also tells them, if you're over on 19, that they can request a waiver based on financial hardship. So they have to be told that too. The amount of security to pay has to be in there. And there also has to be a form, lines 5 through 7, for them to use to request the hearing and the financial hardship exemption. So this is the notice that has to be provided. And that could be provided either by the humane officer handing it to them if they're there, or by attacking it if they're not there. All right, so now moving on, and Senator Hakeem kind of directed us to this earlier, subdivision 3A. So if the person does make their request within 14 days, then the court has to order a hearing, and the hearing has to happen within 30 days after the request. So that you see in the middle of page 19. Then you have the security language. So also page 19 starts in subdivision B, line 16. So the person who requests the hearing, you say, okay, well, if you're going to request a hearing, then you have to post security. And the security has to be in an amount that's going to cover the food and necessary veterinary care for the animal for an initial period of 40 days. And now I should point out now, we'll get to see it in a minute, but these amounts that are referred to in statute are required to be set in a schedule that the Director of Animal Welfare is going to adopt by rule. So these amounts will be specified after the rules get adopted.
Sorry, Rose.
And maybe this is a better question for the Director of Animal Welfare. I guess what I'm wondering is what would happen in the case that the scheduled amount didn't actually cover the required veterinary care? Because I imagine in some animal cruelty cases, veterinary care may be quite extensive, and
Yeah.
as a pet owner, that can be quite expensive.
Yeah. That actually is covered in
Oh, okay.
statute too, but it's actually in some ways it's sort of that kind of connected to existing law, because under existing law, the restitution unit is given the authority to collect some expenses such as that. Now, there isn't any security. This is new. That security part is new, but the way it kind of piggybacks on that, an inappropriate metaphor, now that I think of it in this context, right? Which unpaid security. Let's say the security, they pay the security, but it doesn't turn out to be enough. Well, then the restitution unit can go after them for the rest of them.
Okay.
They're still liable for it. In other words, anyway. So there's that initial 40-day period, the first security payment. Then you see lines 19 and 20, page 19. Then they have to pay, keep paying every 30 days. So there's 30-day periods that. So again, the idea is to try and cover the cost until, see line 21, until the owner either relinquishes the animal or until the court issues an order of forfeiture. So the court proceeding ends or the person relinquishes the animal. Then it would, they would have to keep paying the security at that point.
And I assume if the forfeiture order isn't issued, then the animal would go back to the original.
Exactly. Yeah, we'll get to that as well. Yeah. But top of page 20, this is just what I already mentioned, that the amount of security and the payment schedule has to be set in rules adopted by the director. So what happens with security then? Sort of mechanically how this works. The person pays it because there's this court proceeding going on, right? The person pays it to the court, and then the court transfers it into the Animal Welfare Fund, which is an existing fund administered by the Division of Animal Welfare. So it's transferred to the fund, and then we'll see later on the fund is given the authority to pay it out to the organizations that are providing the custody and care of the animal while the proceedings going on. Does that make sense how that's supposed to work? All right, so then the hearing itself, further down on page 20, subdivision C, state has the burden, you see line 7, state has the burden of establishing by a preponderance that the animal is subjected to cruelty, neglect, or abandonment. Down to line 12, if the state meets that burden, court orders immediate forfeiture of the animal, as well as any offspring of the animal that were born while the animal was in custody. So the animal gets birth while in custody, those are forfeited as well. However, there is two different ways in which as you were mentioning, Senator Wachowski, the animal can be returned to the person. Here's subdivision D. One of them, if the petitioner can show that they were not a defendant in a cruelty case, in other words, they were not the one who committed any cruelty, and they did not participate in it or consent. Over on top of page 21 now, they didn't have any knowledge that the defendant was going to treat the animal cruelly. And if they're going to provide care if it's returned, well, then the court can order that the animal be transferred to that person as well. So there's an opportunity there.
Eric, before you move further along, I'm just looking at time. Kim, do you have a rough estimate of how much time you need?
Yes, sorry, you may have seen the panic in my face because there's testimony in another room that just started earlier that I didn't realize. Our comments are relatively brief, and it may make the most, I know the Director of Animal Welfare is not scheduled for today, but it might make the most sense for the Director of Animal Welfare to speak to the first and then.
Yes.
But again, I know you're not scheduled for today, Lisa, right there. So I'm happy to be rescheduled. I know the civil forfeiture part is going to take a little bit of time.
I also suspect we need more than 20 minutes for Lisa.
Yeah.
Is that?
Yeah.
Am I presenting today?
No, you don't.
yeah, oh,
Sorry.
sorry.
So I mean, we can definitely interested in having you testify. I don't want to put you on the spot. But I also want to be respectful to your timing and schedule. So if, all right, so maybe we'll just keep going for a few more minutes and then shift gears to you. And then since you're prepared for today, and then we'll follow up if needed.
I can also pause right now. It doesn't matter to me. So if you want to have somebody else jump in now, also totally fine.
Well, I think, sorry, for the record, Department of State's attorneys and sheriffs, on the forfeiture piece, the state's attorney, we support the timelines being shrunk. How that's done is sort of act like we wind up involved in the civil forfeiture, but the mechanics of the timing is not something that we have a lot to weigh in on, other than them being shortened. That's definitely where the Director of Animal Welfare speaks most eloquently about. The first few sections regarding the criminal statutes, I'm available for questions, and I have a few comments, but just to give you a sense of where we're.
Sure. Yeah, maybe let's switch gears.
Sure.
Kim.
Yeah,
And then we can revisit the walkthrough, but I think we got through the bulk of the bill.
We did, absolutely. Just the rest of it, really 5-10 minutes. I think you can finish up the end.
Thank you.
You bet.
Good morning, Kim Branis with the Department of State's Attorneys and Sheriffs. And as I just said, we don't have a lot to say on the civil forfeiture part, but I will flag, and again, I would defer to the Director of Animal Welfare to speak further on this. The issue around the notice and tag order, I believe the intent coming out of the House was not to have that be just for emergency situations. It was for when the person is not present, whether the seizure is with a search warrant or without a warrant. So just to flag that part. And that there was a tremendous amount of discussion around the notice requirement, and the Director of Animal Welfare provided a lot of testimony on what's done in other states and notice requirements and the constitutionality piece of how it's been successfully enacted in other areas. And there again, I would request that be how it was handled here if the person is not present and you know where they would be able to see the order. So I did just want to flag that. And
it is just for exigent circumstances, like where the life is threatened.
That's where I do not believe that was the intent. So I just want to.
But that's how it's in the.
That being how it. I don't read it that way, and so that's where I just wanted to flag that.
Okay, thank you.
And then I'm going to leave civil forfeiture alone, other than again to say on the record, from our department's perspective, anything that shortens these time periods that balances the due process rights of the owner, we support. These cases can go on quite some time. And as you'll hear from other witnesses, that's an incredible expense. Part of that expense has made a number of nonprofits, humane societies, understandably leery of taking on the responsibility of housing and caring for these animals. And so we will often have scenarios where we want to get involved and want to have an animal seized, but we may not have a place to because organizations are concerned that they cannot take on the expense of caring for the animal. And I know that's a massive part of that rewrite for that section. And again, you'll hear from the Director of Animal Services. Jumping to the beginning. Sorry.
I don't know who the right person for this question is. I don't know if it's the Director of Animal Welfare, I don't know if it's the Judiciary, I don't know if it's you, but like, how many of these cases are we talking about? Are we talking about 10 animals? Are we talking about 300 animals? Like, what is the landscape?
Well, this can vary considerably. You may have seen there's been a number of cases in the news recently. I don't know how general because of them are active cases. There might be a seizure of 20 dogs that suddenly need a lot of care. The horses are a massive expense. As Senator just mentioned, some knowledge around horses. Anyone who's been around or near a horse, or in any way has had to feed or care for a horse. Incredibly expensive. So if suddenly 20 horses are seized from a farm, which has occurred in our state, that's a phenomenal expense.
Okay, so it can be a
And then-
lot very suddenly.
It can be an influx of a high volume, and then it can also be the one-off, dog, cat. But, and again, and I know, we have someone actually from, sorry.
Central Vermont Humane
Central
Society.
Vermont Humane Society.
Like I said, I wasn't sure if I had the right person to sort of give me the numbers was, but I appreciate you sort of
Yeah,
helping me wrap my
it
head around
can
it.
absolutely vary from a singular animal to 10, 20 more animals. It'll be interesting, and we'd be happy to come back after you all have a conversation, looking at the distinction between cruelty to animals, misdemeanor offenses, and aggravated cruelty. It's always a wonderful, anytime there's an opportunity to step back and kind of look at what has been generated over time, we think is useful, and we would be happy to come back and offer our opinion on whatever direction you all go in. I will note, and we raised this in House Judiciary, that when this sexual conduct definitions were being added, and that this going to be considered felonious behavior when a child is present or involving the participation of a child in these acts. The immediate feedback I received from prosecutors who have had a lot of these cases is they felt similar to you, Senator. Any sexual conduct with an animal in their minds should be considered a felony offense. We raised this in House Judiciary. They did not want to make that distinction, but I do think it's an interesting conversation, along with, sounds like a larger conversation you may have. In general, our department supports this bill. We support the creating the additional offenses and having them be felonies if it is a minor who has been caused to be the participant or who these acts have been done in front of. Again, we don't necessarily think that has to be where the line is drawn for a felony, but we do support the addition. We also support the expansion of the consequences for the movement of the language, requiring the current forfeiture and the future forfeiture of the animal for the second or subsequent offenses.
What don't you support, Kim?
There's nothing that we do not support in here.
You said in general you supported it.
Oh, and this was not a bill that we brought forward. And so throughout the process in the House, we have been supportive of the idea in general. We did a little bit of tinkering on the House side. So what's come to you, we support fully.
Okay.
I just wanted to draw that distinction that Senator Wachowski had raised about where the line is drawn for felony and sexual conduct. If there was a change, we would support that. If it stays as is, we would not throw the whole bill out over that. But yes, and we support the intent behind changing the civil forfeiture. And again, the mechanics of that is absolutely a policy decision, but anything that brings in the timelines of our department's policy.
Thank you. Any other questions for Tim?
And again, happy to come back if there are amendments or changes.
Great. Thank you.
Thank you.
Maybe we're gonna take a 10-minute break and then we'll be back for 10:30